All rise. All persons having business before the Honorable Associated Judges now residing on the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. The first is 22 CM 642 Jeffrey Hamilton Petty versus the United States. And we have counsel appearing remotely. I believe you're still muted, counsel. When you're ready, you can introduce yourself and let us know how much time you would like for rebuttal.
Oh, thank you, Your Honor. Good morning. Russell Bykoff for appellant Jeffrey Petty. I'd like to reserve 3 minutes for rebuttal, please.
Go ahead.
All right, I'm going to begin my argument. Thank you. It's a pleasure to be here, even though I'm not really there.
It feels like you're here.
Yeah, I want to just take a second and wax philosophical, if I may, for a very short time. Try to look at this case from airplane level, about 30,000 feet above. An old judge of mine in Manhattan, when I was at the district attorney's office, Judge Harold Rothwax, used to say, old criminal cases never die. He's paraphrasing the General MacArthur line. Old criminal cases never die. They don't even go away. And here we are, nearly 50 years later, looking at and still teasing out the meaning of a U.S. Supreme Court case named Getters. And we're talking about what kind of barriers that trial judges sometimes place on criminal defendants talking to their defense attorneys. Sometimes there are good justifications for them. There aren't in this case. Sometimes the restrictions are only for a 15-minute bathroom break in the middle of the defendant's testimony, whether it's direct or cross-examination. Other times, the bar may be during lunch, and fortunately, we don't have a lunchtime bar here because that's a very difficult case, I think. Then there are overnight breaks, and then there are weekend breaks with bars. The bars may extend to discussing anything, as in Mr. So-and-so, Mr. Petty, don't talk to anybody about your testimony. Or it may be, don't talk, you could talk about anything you want with your lawyer, Mr. Petty, but don't talk about your testimony. So there are all sorts of permutations in these cases, and that's why we are still here talking about these restrictions on communications between criminal defendants and their attorneys. The government concedes in this case that the trial judge violated Mr. Petty's Sixth Amendment right to counsel with her restriction on his ability to talk to counsel. So that's conceded, and that's no longer part of this case. And I don't think I have any need at the moment to review the trial transcript, which I included in my appendix to my brief, to show what the nature was of the violation and how it, in general terms, affected counsel and the client. So I'm going to skip over that at the moment. The first point that I'd like to make in my argument is that your case, Martin, in an opinion written by Judge Glickman in 2010, absolutely controls this case. In Martin, the court rejected the government's argument that the defendant must show he wanted to exercise his Sixth Amendment rights. That's a so-called trigger or precondition rule that my research has shown me only exists in the 11th Circuit. No other place requires that the defendant pull that trigger and say, look, this is what we want to discuss the testimony. This is what we want to discuss about it. And there are good reasons for that. And Judge Glickman describes in the opinion why the courts generally don't want to, except for the 11th Circuit, don't want to go down that direction. So the only issue today before us is to discuss the so-called triviality exception to the Supreme Court's and this court's well-established rule regarding these mid-trial, mid-testimony, barring orders, sometimes called sequestration orders. And if adopted, how would this triviality exception apply in Mr. Petty's case? The short answer is that my suggestion, my strong suggestion to your honors, is that this is not the case to import the triviality exception, which goes back to a, I think, 2007, 2008 case from 2007 case, Triumph Capital in the Second Circuit in Manhattan. And why not import it into this case? Well, because Mr. Petty's case before us is not really the right vehicle. It doesn't matter. If you import the triviality exception, and I can see there are going to be cases where the violation is trivial, and why not just say it's trivial? You can certainly do that, but it doesn't help the government and will not preserve the conviction in this case, because this conviction.
Before you get to the
Yes, sir.
facts of this case, I just want to make sure I understand what you just said. Are you saying that you agree that there are circumstances, just this case is not one of them, where although there is an overnight ban, reversal would be unwarranted under some kind of doctrine, whether you call it triviality or something else? And is your argument more narrow, or are you arguing, both things? Are you saying it doesn't matter, there really shouldn't be any, in no case could an overnight ban be salvageable by something short of reversal? And in the alternative, even if there's some doctrine where in some cases you could save an overnight ban from reversal, this case is not one of them. Are you making both those arguments? Are you acknowledging that there are in fact some circumstances where reversal is not warranted, and arguing only the more narrow point that this case is not one of them?
I think maybe both, and Your Honor, I think definitely this case is not one of them. There is no way to save this case, no way whatsoever.
Can I ask you, so just to go on the broader issue,
Yes.
For example, imagine that at the end of a day of trial proceedings, the defendant is on the stand, and it's a Wednesday, and the trial court in error says, don't talk to your lawyer, or don't talk to your lawyer about your testimony, or some kind of an order that, if it's going to be for any, an overnight period at least, is not lawful. But there's going to be a 2-week, it's a bench trial, and there is scheduled to be a 2-week break between that and the beginning of court proceedings, because of the other scheduling issues and the like. And so Wednesday night, that order is in effect. And then Thursday morning, let's say sua sponte, the trial court realizes, oh, I should not have done that. And rescinds the order. No court, just issues an order from chambers saying that order is rescinded. In the words of the trial court here, have at it, talk about whatever you want to do for the next 13 days, and then we'll start up court proceedings again. Would you say a reversal is required?
I think that's a good case. That's obviously an extreme case with the 2-week break. Here, the trial judge was very, very concerned about taking too much time for what she considered to be a small case, and she was pushing to get the parties through it, and wouldn't even consider a 2-hour recess. She was flabbergasted by that. But in your hypothetical, sure. Assuming the lawyer found out on day 2.
I don't think there's any value in talking to your client immediately after court proceedings have concluded. Isn't that something lost?
That would be lost.
Right. A trial has a natural rhythm to it, right? And generally, I mean, there are bench trials where there are weeks-long interruptions in between, but in trials that are, 1 or 2 or 3 days, as this one was, there's a pace to it. And then during breaks, as the Supreme Court has said, lawyers and their clients are allowed to talk to each other. That is part of the Sixth Amendment right? And you don't think anything was lost by saying immediately after the proceedings are adjourned for the day that you can't talk to your client? I mean,
Your
it
Honor,
might be difficult to quantify, and it certainly would intrude on attorney-client communications, but you think that's completely without value?
Well, I'm not in the position where I'm going to argue the government's case for it. And I hope you're not assuming that I'm arguing the government's points. Yes, I agree with you 1,000%. The most important conversations that take place are right after court the same day. As the government's case that they're relying upon, Triumph Capital, that Second Circuit case from New York, recognizes, quoting, I think, Getters, the 3 hours after court are the most important time. It's when the defense attorney and the client have a chance to put everything in context, talk about the day's events, talk about, and we're assuming the client is in the middle of testifying, talk about his or her testimony, plan the next day, and then discuss other things. So absolutely, Your Honor, I think those are by far the most important. But to return to Judge McLeese's hypothetical, I think it's a tough case. The damage is done. You cannot shut the barn door after the horse. You can shut the barn door after the horse has escaped, but it doesn't do any good for you. So the damage
Actually,
is done.
I guess,
Yep.
in a way, even granting a mistrial in a case like that can't really, I mean, that the opportunity to immediately consult about that past testimony is irrevocably lost. So a new trial doesn't give you that either. Now, maybe in some conceptual way, a do-over is thought to be better. But let me ask you, this is a somewhat sillier hypothetical, but imagine again that at the end of trial proceedings, the trial court issues an order incorrectly, barring the defendant from talking to the lawyer. And imagine that the defendant is in custody and is going to be returned after court. It's going to be taken back, and the plan was for the lawyer to meet with the defense attorney. I'm sorry, the lawyer to meet with the client, back at whatever facility the defendant is going to be taken to. And on the drive back, the defendant has some sort of a medical problem and is, not conscious, physically unavailable overnight. And then the trial court rescinds the order, before the defendant is in a position to actually speak with anybody. Would you say per se reversible error because there's just no way of, if there is in fact, overnight a bar, it doesn't matter what the other circumstances are, that's per se reversible error? Or would you say in a case like that, it's so clear that that error had no consequence in the real world that reversal is unwarranted?
Well, let me see if I understand your hypothetical. This sounds like a wild one. The defendant's testifying, and
It's in the middle of his or her testimony.
In the middle of his or her testimony, let's assume it's cross-examination, and the judge says, we're breaking for the day. The defense attorney, Mr. Dunham, I don't want you speaking to Mr. Petty about his testimony. I don't want any, I know you're not going to do it, but I don't want you to be tempted. No coaching. We're going to let the Madam Prosecutor have a clean shot at your client tomorrow morning when she comes back, or in this case, he comes back to testify. Now, in your hypothetical, Judge, the client is being put on a bus and going back to the DC jail. The lawyer does not have the opportunity because the judge's order. And also, frankly, as you and I both know, it's very hard to talk to a client who's detained. Mr. Petty was not detained. Mr. Petty was a free man during his trial. So I can tell you from my experience in the DC courts that after trial, after the break for the day, the client goes back to the cell right behind the courtroom. And it's a temporary cell. And you can go there and the lawyer can stand at the bar and hold on to the bar and talk to the client. that has value. It does have value, but it may only last a few minutes because the U.S. Marshals then come and say, counsel, please leave. We have to take your client down to the basement to get ready to go on the bus. That's the end of the discussion. So it's a tough situation. And it sounds like your hypothetical is a lot like that. He's on the bus and you can't talk to him. And you miss that opportunity in the back behind the judge's bench where you're standing at the cell in the block talking to the client. Those are tough cases. And I don't know what to say. It's probably I don't think it's a good idea ever for a judge to say you can talk about anything you want overnight, but don't talk about your testimony. Don't talk about your testimony because you're in the middle of cross. I think that's a restriction that is illegal and it's improper. And here in this case, let me just go through what happened here and go to the facts of this case. Mr. Dunham was kind of smoked out by the court. He felt quite reasonably, I think, that he had to go into a justification, even though under this court's precedents, Martin and the earlier one, Jackson, going all the way back to 1979, the defendant doesn't have to establish prejudice. In this jurisdiction, thank goodness, the defense attorney doesn't even have to object because it's plain error. In New York, to distinguish once again the government's New York cases, New York has a contemporaneously objection rule that applies even to Sixth Amendment violations. So the New York Court of Appeals, which is the top court in New York, and the Appellate Division, Intermediate Court in New York, cases that the government cites here, number one, only one of them follows or mentions Triumph Capital, that Second Circuit case. Number two, they both say that the objection, the Sixth Amendment objection, was not preserved. And number three, they say that the one case from the New York Court of Appeals says we're going to adopt the trivia. Basically, we're going to follow Triumph Capital and adopt the trivia exception. And this was only a what was it? It was a very brief error. Oh yes, the defendant had 2.5 days to speak. I think it was revoked within 3 hours. That's right. Both cases, both Triumph Capital and the New York Court of Appeals case, had the judicial ban revoked in 3 hours. Here, it was an overnight ban. So counsel Dunham couldn't talk to Mr. Petty at all. And the judge, but poor Dunham is there saying, well, Mr. Petty's kind of, he's an excitable person. I've got to calm him down. You can see, Your Honor, he's getting really hot on the stand. He didn't know what to make of the Madam Prosecutor's questions. He didn't know where they were coming from. So I've got to talk to him and reassure him. I've got to establish rapport and confidence with him. I'm his lawyer. Not exact quotes, but this is the gist of what he's saying. And then he says, I've got to finish going through the cross-examination that's going to happen. And then I want to do a model redirect because I'm going to redirect him tomorrow. None of that happens. I think it's crystal clear from the record.
I mean,
Yes,
none of that happened that evening.
None of that happened.
And then nothing else happened before the conversation with Mr. Petty. So you might say, presumably he got to do those very things.
Well, not that night. Not that night.
Well, not that night. Let me press you on that a bit,
Yeah.
because I mean, I think it's clear under all the case law you've been citing that it's not Mr. Petty's burden to show prejudice, or it would not have been his burden to show prejudice if that order had stood and he had to resume the stand without any opportunity to talk to counsel. We presume prejudice in that situation. So no argument about that. But our situation, of course, is different. Those things that counsel would have said to Mr. Petty the previous day, perhaps, maybe overnight, who knows, in the morning before trial, and the things Mr. Petty would have said or asked of counsel, there was an opportunity to say those things. And you seem to ask us to assume that there can be no cure for the lack of opportunity at the end of the day, right after trial. And I just wonder about that. So persuade me on that point if you can, because my thinking is that sometimes it's more helpful to have a conversation with counsel or with the client when each has had an opportunity to back away a little bit and think and regain their composure and decide what they really want to ask and what their points are and reassess what happened in court, or however you want to describe it. Sometimes time helps. And so why should we presume that there can be no cure on what happened here? And again, the relevant points are that the order was unlawful. That is true. We all agree on that. But I think we all agree that no contacts happened, or certainly no testimony resumed, no questioning resumed before counsel had the 2-hour opportunity to speak with his client. Why should we presume in that situation that there was per se reversible error from the order, and that why should we presume prejudice?
Well, that's a wonderful question, Your Honor. Thank you. As you said, it's not my burden. It was not Mr. Dunham's burden to show or Mr. Petty's burden to show prejudice. So I'm not asking you to presume prejudice. Your own precedents and Supreme Court cases, Getters, and what's the other one? Perry, are telling the court that prejudice is there. There's no prejudice inquiry that you need to go into. The issue
Yes,
that
when counsel and client have not had an opportunity to talk because of an order of the sort that we have here. Correct.
so
But they don't deal with this specific situation, do they?
Well, this
i.e. nothing happened. The testimony didn't resume after the unlawful order until after counsel and client had had an opportunity to speak the next day.
So you're asking me whether the 2-hour recess the next day was an adequate cure. That's really the question. Was this constitutional error cured? And my answer is not in this case. And my broader answer is it's very, very difficult to cure an overnight ban like this in general. And here specifically, it was not cured. The reason it's not cured is the harm had already been done the night before. Remember, we're talking about structural error, and there's no harmless error analysis that your own precedents permit. So we're not going into harmless error. We're not going into the strength of the case.
I get that, but once again,
Okay.
I think I'm drawing a correct distinction. And if you think I'm not, tell me. I don't think our other cases tell us the answer to whether prejudice is presumed on facts like this, where there is the unlawful order. Nothing happens between it and the time when the court says, have at it, go ahead and talk to your client. There is the conversation with the client, and then the testimony resumes.
Well, I
What-
think
What about Getters, counsel?
yes. Well, Getters,
In
Yes.
Getters, there's an overnight ban. They come back to court. Counsel asks to put his client back on the stand on direct instead of going straight to cross. That request is granted. Then there's a recess. At that point, counsel is allowed to talk to his client. Nonetheless, the Supreme Court said the overnight ban violated the Sixth Amendment and is reversible error.
I think that's where the inquiry ends. The inquiry ends here on, I think it was July 12th, which is the night that Your Honor, both of you, Judge Thompson, Judge Easterly, that's when the ban goes into effect. That's the first, I don't know if it's the first day of trial, but let's call it the day that the ban goes into effect, July 12th. So at that point, you're looking at structural error. And incidentally, I commend to your attention a very interesting case with an opinion by Judge Posner from the 7th Circuit, U.S. Circuit in 2000, maybe 2010. And I have that case for you. He talks about Triumph Capital, and he kind of poo-poos the distinction between where Triumph Capital says, well, look, we're not going into harmless error because that's not permitted. We're just talking about trivia. And Posner says, well, you're really talking about harmless error because the whole, even though you're not supposed to be. So he clearly doesn't think much of the trivia exception, and he doesn't use it in his case.
Are you talking about the Goya case?
Which is Gaia or Goya. Yes,
Okay.
Gaia is very interesting. There, the court, Posner's opinion, Judge Posner's opinion says, well, look, here the judge prevented the counsel and the client from talking about prospective possible examination by the government of some phone records, which the government was going to use to impeach the client who was already on the stand. Judge says, don't talk about these phone records overnight. Don't go there. Don't go there. And the next day, lawyer comes in and says, Judge, you violated my client's Sixth Amendment rights. Couldn't talk about the phone records. Judge says, oh, I wanted to think about that overnight. I didn't want you to waste your time. I'm going to prevent the government from going into these phone records. So there's not going to be any cross-examination about the phone records. So there's no need for you to consult with your client about them. I'm not even going to give you a break now because that's also a waste of time. Judge Posner says the whole issue is moot. There was no Sixth Amendment violation. It didn't happen. There was no error. He says squared. So he cites Triumph Capital, but doesn't say it was trivial. He just says there was no error. So that's another good approach. In Mr. Petty's case, there was error, Judge Thompson. There was structural error. At that first day when the ban went into effect, nothing that could happen the following morning could cure it, as Judge Easterly pointed out, under Getters and under the Judge, well, the case, the Martin case here, which is a very good guide and controls this case.
Counsel, we've kept you beyond your time, and I think
sorry.
we'll hear from the government now, and we'll give you an opportunity to speak after the government.
Thanks, I'm going to mute myself then.
Thank you.
May it please the court, Ann Park on behalf of the United States. While Mr. Petty's right to the effective assistance of counsel was delayed or deferred by the trial court's order prohibiting him from discussing his testimony with this defense counsel overnight, it was not denied altogether because Mr. Petty was ultimately able to receive the unfettered advice of his attorney the very next morning. And in light of the circumstances, of the limited circumstances of this case, the trial court's sequestration order was so trivial that it did not meaningfully interfere with Mr. Petty's right to the effective assistance of counsel and did not amount to a Sixth Amendment violation. And the government here is asking the court to adopt the triviality standard.
Can I make sure? I just want to make sure I get the arrow of time right. So let's say it's the morning after the recess, the overnight recess, and we're in, we're the part of the transcript where we're in court and deciding what to, the trial court's deciding what to do and hearing from the parties. Are you saying at that moment there hadn't yet been a Sixth Amendment violation, or do you concede that at that moment there had already been a Sixth Amendment violation? Or do you think that I get the arrow of time a little confused in what you're saying?
Yes. So it's the way that triviality standard is discussed. It's so insignificant or small, or there's not been a meaningful interference.
Well, I'm trying to ask you a chronological question. So here's my question exactly. At whatever time it was, 9:30 in the morning on the next day, at the time the parties are deciding what to do, debating what to do, and the trial court's deciding what to do. At that moment, had there been a non-trivial Sixth Amendment violation of Mr. Petty's rights?
No, Your Honor. And I say this, I understand there was definitely an infringement. I think that the problem is when you use a triviality analysis, you're looking at the totality of the circumstances. So Your Honor,
trying to decide whether to use a triviality analysis. So can we stop right there and say, okay, so as of 9:30, there's been an overnight embargo on counsel speaking to his client, on the client speaking to his lawyer. And you're saying at that point, there's no Sixth Amendment violation?
There is a it's hard. At the end of the day, after looking at the totality of the
Because that
circumstances, there
seems
is
like
no
a hard
violation.
argument to make under Getters,
Yes.
Jackson, and Martin.
Yes, if trial had resumed the next morning and Mr. Petty had gotten on the stand immediately, there was no opportunity for him to confer with his counsel in a meaningful way. That would definitely be a Sixth Amendment violation. It would be structural error. There would be no prejudice analysis, and we would have conceded error. I mean,
Okay,
we say that
so-
in our brief.
so
We would
it's-
have conceded error.
Okay, so at that point, there's a violation, and so you're saying that it's only because of what happened. And I just didn't quite understand from your brief. Are you saying that what happened converted the error into non-error or made the error not reversible error?
We are saying what happened made the error so trivial that it did not amount to constitutional violation. And
So
this
it
is
made
what-
it non-error.
Yes.
So
And-
you have to pull back and look at the full lens, you're saying, and so now it's not error anymore.
In
And
light of what transpired.
in light of what happened. And so what happened was they go back to court at 11:30, right? And so this ban has taken place overnight and into half of the day.
Yes, approximately 19 and a half hours. That's my calculation.
Okay, I was curious about that. I couldn't figure out when they recessed the day
They
before,
recessed
but it-
at 5, and I think on the record, there's notes that they were going to break at 12:15, but I think the break actually happened. There was a little bit more discussion, maybe 10 minutes later, 5 to 10 minutes later. So
Okay.
I would say about 19 and a half
Okay,
hours.
so the embargo goes through, close to noon the next day. They come back. And at that point, counsel says, I need to bring this up again, right? I think there's been an error here. You kept me from talking to my client. And the court doesn't seem particularly interested in hearing about it, but counsel pushes forward and says, I want a 2-hour recess, which with the government's acquiescence is granted.
Yes.
And you're saying that it's the 2-hour recess that turns this into non-error.
The 2-hour recess and the fact that defense counsel came back and he told the court asked him, have you been able to talk to your client about everything you want to talk to? And he says, yes. He
Right.
doesn't ask for more time.
And I guess I find that a little puzzling because the Sixth Amendment right to counsel is personal to the client, right? To the defendant. So I'm trying to understand what value counsel's statement of I got to talk to the client about everything I wanted to talk to him about has in assessing whether or not this is still structural error or, in your view, trivial.
Your Honor, it's not they talked and we have talked about everything we need to talk about, and the defense
That was
counsel.
counsel's representation.
Yeah, it's representing, and
Did he-
that's how we know whether defendant is satisfied or not. If the defendant wanted to have
Is
more
that
time,
right?
did not feel comfortable.
In matters of representation, we know because counsel said so.
I'm not sure in
Do you have
that, I
a
mean,
citation for that?
Your Honor, we're talking here about the effective right to representation. Defense counsel comes in and says, my client wanted to talk to me last night, but he couldn't. I'd like 2 hours to talk to him now about everything I couldn't talk to him about. And he was very specific. He really wanted to go through a model cross and model redirect. They have the 2-hour break and he comes back and she says, have you been able to talk about everything? And he says, yes. I don't think he's asserting that he's representing his client. His client is comfortable with the time they had, and he's representing that to the
How
court.
do we know that? I'm not trying to be cute. I'm just trying to understand where on this transcript do we hear from Mr. Petty that he's entirely comfortable with this?
We do not hear from him directly, for sure. We hear from through his counsel.
Right.
They're ready to go on. He does not ask for more time. I think you can reasonably infer that his client is satisfied with the time they had together to talk in a meaningful way.
Can I
And Your
ask you,
Honor,
just
this kinda gets-
hypothetically, how would you analyze this case if what had happened after the 2-hour recess is the defense attorney had come in and said, I tried And, it would have been a lot more effective if I could have spoken to my client at the time I was constitutionally entitled to. And I don't think what happened here has been an adequate remedy. It hasn't fixed things. Would that have meant that? What should have happened next? Would the trial court be required to grant a mistrial if that had been requested, saying this is per se reversible error? It hasn't been reduced by circumstances that, in your view, kind of retroactively make it non-constitutional error, maybe non-structural error. So would the trial court be obliged to accept that representation? Should the trial court have a hearing, put the defense attorney and the defendant on the stand and figure out, well, how good was the conversation? How is it supposed to work practically if you have different representations that continue to raise concerns?
Your Honor, I think that would make it much more difficult because under Triumph Capital, the triviality standard, you have to look at the cure and whether they were able to have a meaningful discussion despite the ban. But
And that seems problematic, right? I mean, for all the reasons that the DC Circuit discussed in Mudd, right? We really don't want to intrude on what the nature of these conversations are that counsel has with his client. And I just want to take you back to the transcript. The question is, Mr. Dunham, did you have an opportunity to speak with your client? Yes, I did, Your Honor, in a way that you wished I had. Thank you. That's the lawyer's, the lawyer got his agenda out, but who knows what the client wanted to speak about with his lawyer the night before or the day of. A 2-hour recess, which as the judge made it clear was going to include the lunch break, is nothing near an overnight recess that would go from 5 p.m. to 11:30 in the morning.
In these cases, so there's no discussion about whether the defendant should represent on the record in these cure cases that he satisfied.
There's no body of cure cases. There's the Second Circuit, right? Which really does seem to be getting at something different, right? I mean, Judge McLeese was hypothesizing about a situation where there's an alternative impediment to the client communicating with his lawyer, right? It's not that, for lack of better terminology, the court's order is not the but-for cause of the interruption between the communications, right? If the client suddenly has a medical event and is unconscious, right? Like the court's order is not the reason that the Sixth Amendment was violated, right? And similarly in the Goya case, I guess you could say, right, if the lawyer is so express, and that's what Posner seems to be honing in on, so express that the only thing they needed to talk about was about the telephone records, and then the court strikes the telephone records, then we can say, okay, there's no violation there. But I don't see in this case how you can avoid getting into the nature of the communications that the client wanted to have with the lawyer, as well as the ones that the lawyer wanted to have with the client. And that seems like extremely dangerous territory.
Sure, Your Honor. But here, I think all that was mentioned, and he specifically said, I don't want to go into attorney-client communications, but he made it clear that he wanted to, there are certain questions on cross-examination that the defendant was not comfortable with or didn't understand. He wanted to discuss them, and they wanted to talk about the testimony the next day, his cross-examination and his redirect, and they were unable to do that. That, to me, seems pretty general, doesn't talk about the substance of any conversation.
I mean, that was the representation before they actually spoke. Right.
Yeah, yes.
But who knows where these conversations go?
Question. I think in that situation, if the court, if the defense counsel says, there's no way we can cure this, I really needed to talk to him last night. It's not the same for whatever reason. If he gave reasons for why it could not be cured by just talking to him the next morning, I think the court would have to try to find a way to cure it as best as she can. If she can't, I'm not sure whether a motion for mistrial should be granted, but on appeal, certainly that is a factor. The fact that defense counsel represented to the court, trial court, look, thank you for the time, but it really didn't resolve the issue that needed to be resolved.
It doesn't seem like a factor. It seems dispositive under Getters, under Jackson, under Martin, that there was an overnight ban. And I guess I want to take you back to Getters, right? For this, on this conversation of cure, right? As I mentioned earlier, the facts in Getters are that there's an overnight ban. And then they go back to court, and at defense counsel's request, defense counsel asks to reopen the direct. And then after the direct is over, defense counsel asks for a recess at that point, and defense counsel's request is granted. So defense counsel has not now received two things that he wanted, arguably to cure whatever problem occurred. And the Supreme Court doesn't say, well, there's a cure, never mind, the overnight recess doesn't matter anymore. The Supreme Court says there was an overnight embargo on communication between the lawyer and the client, and that is constitutional error and reversibly so. I don't understand how this cure argument.
In Getters, it's kind of strange. I think the break was taken between direct and cross.
Exactly.
And then, yes.
And
but
direct was extended at defense counsel's request when they came back to court the next day.
But I think they went through cross-examination, and then petitioner, whose testimony on redirect was yet to come, was permitted to confer with this attorney during the noon recess. So, and it doesn't make clear whether the ban was on test, whether they could talk about the ban in Getters was about anything.
I'm reading from Getters. When the court convened the next morning, petitioner's attorney asked and received permission to reopen his direct examination of petitioner. The cross-examination which followed was finished in the morning. Okay, so then they did cross.
Yes,
then they had
cross.
lunch and the recess. But there's no conversation about cure,
and it's
that the direct is reopened.
Case, two things happened, if I'm following what Judge Easterly read. Direct resumed and some cross happened. So something did happen between the time the court said no talking to your client and the client's having to get back on the stand and get through direct and get through cross. And I think it would be very difficult to say anything about whether there could be a cure, because who knows what would have affected the client's answers on direct and in cross, but we don't have that here.
That's exactly right. And
We don't have anything happening. Client does not get on the stand to do anything before, and nobody examines anybody before client and counsel have an opportunity.
That's correct. And that's why I think Getters is not a cure case, because of the specific facts in that case. And it's really not clear. They don't really talk about what conversation was permitted, whether there was a limited ban or not. It's just,
Maybe they don't talk about it because they don't care, right? They don't talk about it because there was an overnight embargo, just as there was in.
But you're
in this
saying
case.
Once there's an overnight embargo, there is harm and there's a violation, and it can never be, regardless of what happens afterwards. It can never be.
I'm not
reversed.
saying
And
that. I'm saying that our cases have said in scenarios like this, and certainly we haven't encountered scenarios such as Judge McLeese has posited, right? Where there's a much longer, right, interruption in the proceedings. And one could argue perhaps that that the embargo is not some sort of, meaningful interruption of communication, right? Or is not the but-for cause of the interruption, right? And that seems to be, Triumph is miles away from this case, right? There is no overnight embargo in Triumph. And the Second Circuit is quite clear that it's making a very, very narrow ruling, right?
Yes.
And it says,
limited circumstances
we're going to
and
list
narrowable.
7 factors here that show just how narrow this is. And then it says, and if one of these factors weren't present, we're not sure we would rule the same way. We wouldn't find this trivial. And at least one or more of those factors aren't present in this case, right? Because one of those factors was actually it wasn't an overnight embargo. It was only a couple hours, right? Yes. Here, it was an overnight embargo. So it seems like if we were in the Second Circuit, Mr. Petty would win.
That's not true, Your Honor, because there are certain factors here that are not present in Triumph Capital. I think that it's true that a factor was the length of the ban. When was it rescinded? But in practical effect, in Triumph Capital, the ban was rescinded 3 hours after court ended, but defense counsel and the defendant was out on release in that case, was unable to contact or talk with the defendant the entire night. So in practical effect, the ban was actually in effect the entire night. And then the next day, the court was very willing and obliging in giving defense counsel the time and defendant the time they needed to confer. And after 45 minutes, they came back and she said, is everything okay? Were you able to talk without any restrictions? And defense counsel said yes. And then they resumed the testimony of the defendant. I mean, in practical effect, what happened in Triumph Capital is what happened here. But I understand they found out about the error sooner. It's just that circumstances made it hard for the defendant at that point in time to make contact with his client and have a discussion. But in reality, they didn't talk until the very next morning. So
No,
the
I mean,
facts
it wasn't
are the same.
circumstances. One of the factors that Triumph highlights is counsel admits he could have contacted the defendant to make it arrangements to speak later that evening, but made no attempt to do so.
Yes. And
So it's like another intervening circumstance, except that the intervening circumstance is arguably ineffective assistance of counsel.
And I think the Triumph Capital explains why that's a significance, because if the ban is in effect, that means they're not talking because of what the trial court did, right?
Right.
Once a ban is lifted, then it's up to defense counsel and the defendant. The court can only give them the opportunity to have a meaningful discussion. Whether they choose to take that opportunity depends on what they do. So that's why the court was looking at that as a factor. And I totally get it. I mean, the facts are very different here. The ban was not, no one knew it was erroneous
For 19 hours.
until, they showed the cases. Even then, the
Well,
judge was
actually,
pretty
the defense attorney
obstinate.
knew it was the defense attorney knew it was erroneous from the get-go.
Yes,
The defense
yes,
attorney
yes.
was objecting all
Yes,
along.
yeah,
So
and-
it's a little
yeah.
broad to say no one knew. The defense attorney 100% preserved the idea that this was illegal. The
Yes.
front end, at the back end,
Yep.
at all points. So
Yep. And he didn't have the specific case. The judge asked for cases and he knew, nobody else knew. The person who made the decision didn't know. So that's where we are. And this is
Can I
how
just ask
Martin
you-
is different though. That's
Well,
not,
Martin, is exactly where I wanted to take you, right? I mean, in Martin, we say that an unobjected to getters violation per se seriously affects the fairness of the proceedings.
Sure.
Right? So how do we get from Martin to a triviality rule where we say, well, we can cure it? I don't,
so Martin
I
was a
can't
plain, Martin was a
that
plain
far.
error case. Martin and Jackson were both plain error cases. And in that case, once a ban was imposed, defense counsel never objected and defense counsel never asked for any sort of relief at all.
I understand that. But if in your analysis, you were saying this is the type of error that we are going to say, we don't have to do any fine balancing to figure out if this seriously affected the fairness of the proceedings. It just does. It's structural error, and therefore it satisfies this prong of the plain error test. I don't understand how we get to the cure triviality. This is no big deal. After 19 hours, we can just forget it ever happened because, hey, defense lawyer got, a 2-hour opportunity to confer with his client, including the lunch break. And then he came back and said, I got to ask him everything I wanted to ask him.
Well, Your Honor, I think the answer actually lies in Triumph Capital and actually Gaia, which relies on Triumph Capital. Triumph Capital makes very clear that the triviality standard is very different from a harmless error inquiry. When we talk about harmless, we're talking about harm in both cases. When you have a Sixth Amendment violation, obviously there's harm to the defendant. His constitutional right has been violated. But when you look at harmless error inquiry, you're looking at the effect the error had and how it contributed to the verdict, and whether, if the ban had not existed, there's a reasonable probability that the trial would have been different, or you look at the overwhelming nature of the evidence. We don't care about any of that here in triviality analysis. The harm that you're looking at is how significant was the deprivation.
Right.
Can we say
but
that-
I don't mean to cut you off, but that's why in Martin, we say it's structural error. We're not going to parse
But
this any
Martin-
more finely.
But Martin had no opportunity to address the issue of triviality, because in that case, there was no objection by defense counsel, and there's no request for any sort of relief. So Martin did not address whether something was the error, potential error was cured because they actually had a meaningful opportunity. That's not in the fact pattern. It just, the ban happens, no one says anything, and he resumes his testimony. Martin doesn't address, they had no reason to address Triumph Capital, and then actually it cites a Triumph Capital, but only for the first half of Triumph Capital, which if a ban includes a discussion on testimony, Triumph Capital looked at a lot of federal circuit cases and they all said, a ban on testimony violates a defendant's Sixth Amendment right. And that's the law in this jurisdiction, and we do not dispute that. But it had no opportunity to address the second half of triviality, second half of Triumph Capital, because in Triumph Capital, it cited all those cases, but it found that there was no Sixth Amendment violation because of triviality in any event. So Martin had no opportunity to address it.
Can I ask you, I want to make sure I understand the distinction you're drawing between the triviality exception that you are arguing for and the harmless error analysis that you are saying you're not relying on. And so, I mean, I get an aspect of it, I think, but I just want to see if I'm getting your point correctly. So if you were applying conventional, let's say, constitutional harmless error analysis, at least ordinarily, the inquiry would be whether the error in question had an effect on the outcome of the proceeding.
That's correct.
And I take you to be conceding that that's not what the triviality inquiry is about. And so even if on this record, we could say, we just are quite confident, we could say beyond a reasonable doubt that the outcome of this trial would have been the same if there had not been this order. That wouldn't, in your view, you're acknowledging that's not the right way to, that's not the right way of analyzing this. That wouldn't be a lawful ground on which to be affirming. Is that correct?
That's correct. It makes absolutely no difference. We don't care if there's a mountain high pile of evidence showing the defendant's guilt. His guilt or innocence does not matter. We are looking at the nature of the violation.
We're looking at a not effect on the outcome of the proceeding prejudice, but instead, if I understand the distinction you're drawing, we're looking to see if there was prejudice to the defendant's Sixth Amendment interest of a kind that either should be treated as per se reversible or that or structural or trivial or whatever word you want to describe in contrast to that. And that is a focus not on the outcome of the proceeding, but on what the record shows and what otherwise one might be concerned about or infer about the effect of this order on the actual Sixth Amendment interaction between the defendant and the defendant's lawyer. Am I getting the distinction right? Or?
That's absolutely correct. And Your Honor, and Triumph Capital actually discusses it at pages 134 and 135. And Gaia, which is, I find is a little weird case, because I think they found invited error in that case. But I actually thought, in contrast to Mr. Bykoff's view, that Judge Posner, who wrote Gaia, actually agreed with Triumph Capital's analysis of triviality, but said it doesn't apply here because the error here was invited. And so even under structural error cases, invited error, he's waived it. That was my understanding of Gaia. But Gaia was looking at, you know, a whole bunch of standards that arose in that case: invited, triviality, harmless error, structural error. And the court did not have to draw on triviality because it found the error was invited. But it does talk about it. And I think actually Judge Posner agrees with the Second Circuit in Triumph Capital.
If the inquiry that we're supposed to be focused on, in your view, is not outcome of the proceeding, but actual practical interference with the interaction between the defendant and the defendant's lawyer here, if that's the inquiry, how sure do we have to be that there was not any or not enough to affirm on that ground? And that's part of why I was asking the question about what about a different record where the defense attorney comes in and instead of saying what the defense attorney said here, the defense attorney says, actually, I just don't think this has been an adequate remedy. It's too little, too late. Is it sort of a Chapman kind of, we need to be sure beyond a reasonable doubt that there was no actual practical interference because of the cure? Or, I mean, what degree of certainty are we supposed to be looking for? And if you have light to shed on that, I guess that's my question.
Your Honor, I don't, there's no standard let's set forth like that. I mean, there is language, and it's quoted in the government's brief. The way the Second Circuit phrased it is basically when in the totality of circumstances, a court order banning communications during a trial recess, even if unjustified, is issued in good faith and does not actually prevent the defendant from communicating unfettered with his attorney about the full panoply of trial related issues prior to the trial resuming, nor meaningfully interferes with the quality of advice and and counsel the attorney is able to provide during that recess, the fundamental values of the Sixth Amendment that Getters protects have not been subverted. In such limited circumstances, a restriction may be deemed trivial and judged not to amount to a Sixth
So
Amendment
this just
violation.
loops me right back to my concern about intruding on attorney-client communications. I have no idea how you figure that out, right? And it seems to me that the reason that there's no standard, right, why we don't know the answer to Judge McLeese's question is because the Supreme Court never envisioned it playing out this way. What the Supreme Court said in Getters is, look, you have an overnight embargo on attorney-client communications. That is per se reversible error under the Sixth Amendment. It is a violation. And then under Perry, they said, well, look, we're not going to get into the quality of the communications, but we can say if it's just like a 15-minute, bathroom break, that's not going to be a constitutional violation. We are going to go purely on time, right? If it is a substantial break of the sort that clients and their lawyers usually talk to each other, right? And as part of the rhythm of a trial, that's a Sixth Amendment violation. If it's an insubstantial break temporarily, we will not, right? And there's a fuzzy line there to be sure, right? And we don't know where that line is, but we don't need to know that line in this case. There was a 19-hour break. Seems totally on the Getters side of the line. And we don't have to do this kind of intrusive, what was the quality of the communications? And did the lawyer, and the client actually have meaningful Sixth Amendment conversations? That seems like a not ideal way of doing it. And it seems notable that no one has followed the Second Circuit's lead on this.
I think there are not a whole lot of cases on this issue because I'm hoping that trial courts know better than to instruct defendants overnight that they can't talk to their attorneys about their testimony if they're on the stand. I mean, unfortunately, the parties here were not fully informed of the case law, but those cases have been on the books and Martin is strong. There's not
What do
a
you
whole
think
lot
the
of cases on
downstream
it.
effect, though, is if we say actually Getters and Perry aside and Jackson and Martin, it's actually a super loose rule, right? Like this can be dispensed with some sort of triviality analysis. Do you think that courts are going to be very mindful of the rule against telling lawyers not to speak to their client during recesses?
Yes, because it's error. They should not be telling defense things that, this court has said is constitutional error. I don't think any
It's an
trial judge
error
wants to do
without
that.
much
Do you
fight.
think, Ms. Park, we'd have a different case if counsel, when asked by the court, did you have enough time to talk with your client, had said something like, well, Mr. Petty has a headache this morning, but I think we had enough time to talk. Or if he had said, Your Honor, Mr. Petty told me that he didn't sleep well last night, but we've had enough time to talk. Would that make a difference?
It makes a slight difference. I think at the end of the day, a headache and they expressed that they had enough time to talk, that would be sufficient. I mean,
what I'm trying to get at
Yes,
is if
yes,
there was
if there are
some
other
indication
factors.
on the record that maybe the client wasn't as able that morning to concentrate, participate, express his views and thoughts as he might have been the prior day, would that have made a difference?
I think it does have to make a difference in the totality of the circumstances.
Do you think the trial judge needs to have an inquiry and ask the defendant, how are you feeling? What did you think about your opportunity to talk to your lawyer?
No, Your Honor. I mean, if defense counsel wants more time, I think they can ask for more.
So a silent
Or ask
record,
for
a
more
silent
recess.
record is against the defendant. We presume that the defendant had a full opportunity to speak to his lawyer without any sort of distraction, physical impediment, unless that's elicited voluntarily by the defense. There's no obligation on the court to suss that out.
No, Your Honor. If defense counsel says he's had a headache, but we've had enough time.
But no, my question is silence counts against the defendant for triviality purposes.
If he doesn't ask for more time or for additional recess, I think that would have to count against him. Your Honor, I think I just want to go back to Getters, Jackson, Martin. Those cases really did not address the specific facts here. And I don't think just because they say nothing about triviality that this court can't adopt a triviality analysis. Even in other, I mean, Triumph Capital talks about in the related context of the Sixth Amendment right to a public trial, it cites the cases where the courts have found, federal courts have found that just a closing of the courtroom for brief reasons, it's trivial. So it does not amount to a Sixth Amendment violation. So in other areas of the constitutional law, there is this triviality standard. It's not like it's brand new.
This court has never adopted a triviality analysis in courtroom closure cases.
The only case I know is a Barrows case, which was plain error, although a structural error was plain error, and it found in the fourth prong that there was no fundamental miscarriage of justice. So it hasn't yet, because it hasn't been presented with the opportunity to do so. All this to say, Your Honor, is this triviality standard is not something that has just been pulled out by the Second Circuit. I mean, if you read the DC Circuit's opinion in Mudd, which is actually a pre-Perry case, there the DC Circuit was trying to,
It presages Perry, right? I mean, it actually,
It does.
and it leads to the distinction that I was talking
Yes.
about. It says, look, we're not going to intrude into the attorney-client relationship. And so maybe there's this temporal distinction where we can say, 15 minutes is too short to have any, qualitative effect on the attorney-client relationship. But we are not going to get into the nature of the communications that they had, because that is way too dangerous. That is what Mudd said, right?
it did talk about that, but it also,
And then the Supreme Court just picked that up in Perry.
well, no,
lo
in
and behold.
presaging Perry, Mudd actually talks about triviality. It says some violations can be so insignificant that it does not amount to a Sixth Amendment violation.
But it was talking about the temporal nature.
Yes, it was talking about the 15-minute break.
It wasn't
So-
talking about qualitative. It was saying temporally they can be so insignificant. I
Yes,
think
yes, yes.
if you're suggesting otherwise, I think you're taking the quote out of context.
No, I'm not suggesting otherwise. It was actually looking at federal circuit cases that have held that harmless. They were looking at Sixth Amendment violations and short recesses. At the time, it was before Perry, so no one knew. There was no line to be drawn. The Supreme Court hadn't drawn a line. So the federal courts were everywhere in terms of overnight break versus 1 hour break versus, 15-minute break. And it was talking about, in some cases, the court has found that any violation was harmless. So they did prejudice analysis. The DC Circuit then said, we think a better way to look at these short recess cases is to say the violation is so small as to be insignificant. It's trivial. It's basically saying we would decide this case. I don't think that case was, those short breaks were presented in Mudd, but anyway, we would decide this case on a triviality analysis. So it's not as if this standard
They never use the word triviality.
No, they don't, but so small and insignificant. I mean,
temporally.
yes, I understand that. But but to your Honor's point that
But in that case, it was an overnight recess.
yes,
Right.
it was.
And so they were saying, this is not an insignificant break, right? This is not
Yes,
an
yes.
insignificant interruption.
But it was in saying and analyzing the short recess breaks. They, instead of following the courts that have said it's harmless error,
Right. I'm
they
just
said,
pushing back on you saying that Mudd is fully aligned with Triumph.
no, I'm not saying it's fully aligned with Triumph. I'm saying that it deals with triviality years before Triumph Capital discusses it in this context. And actually, Perry does not decide. Perry doesn't decide the short recess on triviality
I don't
either.
mean to extend, I'm not seeing how it deals with triviality in the sense that Triumph did, right?
And I agree with Your Honor.
Okay.
My only point was to say that this triviality standard is not something new that Triumph Capital pulled out of the air in the context of attorney-client bans on communication. It's something that's been out there, that's been discussed. I would argue Perry doesn't actually adopt a triviality standard. They say the break is so small, we can just presume that the conversation is going to be about the testimony, which technically you're not really supposed to talk about, but with overnight recesses, because the time is so long, it's like you're going to talk about other things besides testimony, but the testimony can be touched upon it. So we're going to err in favor of the Sixth Amendment. That's how they distinguish the short breaks. They don't actually apply a triviality analysis. My only point is the DC Circuit in Mudd was saying, well, we would employ what is essentially a triviality analysis for these short recess breaks.
Can I ask, if I'm following your line of thinking, it's that you could think of the temporal limits as sort of a subcategory of the general abstract idea of triviality. And they played out in a particular way in that setting. And that got me wondering about other kinds of triviality. And so are there cases that you're aware of? I have to say I didn't focus on them. So I don't know what the law, if any, is on this, where, I mean, obviously Goya is an example of this in a way, but where the order is like very discrete. Talk about all the testimony, talk about everything, but don't talk about some particular thing. And depending on how important or unimportant that thing is, you might or might not view it as either structural error or constitutional error or not constitutional error or harmless error. But is that another like subject matter, like scope triviality? Is that another area beyond Goya? And is your abstract theory, which is some of those errors might be some restrictions on discussion that are overnight, so they're too long in duration, but they're narrow about subject matter to like particular topics, teeny tiny ones or irrelevant ones or whatever, end up either not being violations or could be viewed as trivial or could be viewed as harmless or somehow wouldn't be required grounds for reversal. Is that another area that you have in mind or that there's law on that you're aware of beyond Goya?
I haven't really seen that much law on it. The only case that's, I don't know the name of the case, but I think you could employ triviality analysis. I think in those sorts of cases, it would be better to weigh what the Sixth Amendment right is protecting and why the order, the very limited discrete order, was imposed. And I think a lot of these Sixth Amendment cases that talk about bans, they're balancing his right to have meaningful opportunity to talk to his counsel with other interests. So, for example, the case I'm thinking about, and it was generally doing research. It was an order on testimony that related to concerns about witness security. So the court ordered the defendant not to talk about something that could, a defense counsel to talk to the defendant about something that might harm a
Protective
witness.
order.
Yeah,
Protective order.
And I think in that case, the bans on communication, they always say, is it narrowly tailored to affect the interests that the court is trying to protect? Or is it so broad that it violates the defendant's Sixth Amendment right? I think that's a better way to analyze those cases to me, because it seems more of a balancing between competing or conflicting interests and rights, which courts do all the time, versus imparting a triviality analysis. Trivialities, I think the short break can be viewed as kind of a triviality analysis, although it has not been analyzed that way. But the triviality cases in this context seem to arise when there's been some conduct that's happened after the ban has been in effect and lifted, and the defendant gets an opportunity to talk. Now, the court may disagree that in this case, the facts don't align with Triumph Capital, but we are asking the court in any event, we think they do, but in any event, we're asking the court to adopt the triviality standard in Triumph Capital. If there are no further questions, we'd ask that the judgment of the trial court be affirmed.
Thank you, counsel. Thank you for your extended argument. We appreciate your time at the podium. All right, Mr. Bickoff, we'll hear from you just for a few minutes, please.
Thank you, Your Honor. At the risk of beating a dead horse, I'll just plunge right back in and stop me if you've heard enough. Triumph Capital is not a good vehicle for this case. It's fact-bound. Its stated test of the 7 factors doesn't help the government in this case to preserve the conviction. The government is conflating a triviality test with a cure. As Judge Easterly pointed out, there are distinctions between there's a difference between talking about triviality, talking about a cure. In this case, you had neither. You didn't have a trivial violation. Please look at what the transcript here, what Mr. Petty said and what his lawyer said on that day that the ban was imposed. The poor client couldn't believe it. He was shocked. He says, "You mean I can't talk to my lawyer?" Imagine all the intangible effects on him. And then the trial counsel is flabbergasted because this sounds like for me reading it, it sounds like the first time he's ever come across this kind of ban. So, and then contrast this with the facts in Triumph Capital, where the attorney goes home, maybe to Westchester or Long Island. He doesn't bring his note. He didn't take notes because they thought he was going to talk to the client right after court. He didn't bring his file. He goes out for pizza dinner. The client goes to a prayer meeting, turns off his phone. So Triumph Capital is looking at the actions of the court, but it's also looking at the actions of the defense attorney and the defendant. And it's probably not a good way to analyze these things because of attorney-client privilege and ineffective assistance of counsel. And we don't want to start to go down, all these different paths of analysis when we're really talking about Sixth Amendment right to counsel. So in this case, it was the actions of the court, and there was no, Mr. Petty and Mr. Dunham, the attorney, had nothing on their responsibility that contributed to this 19-hour break. Finally, I like to direct the court's attention to step back, take a look at Sixth Amendment values, and please look at the Justice Marshall dissent in Perry. There, it was a 15-minute bathroom break that the majority upheld, but Justice Marshall says, let's not go there. Let's not begin carving out exceptions even for 15-minute bathroom breaks. They should be allowed to talk about anything they want. And he spends a couple of pages talking about the importance of the Sixth Amendment right to counsel and how essential it is in our criminal justice system for defendants who are facing jail time, deprivation of freedom, and Justice Marshall talks about the benefits to the administration of justice. He even suggests that the client and the defense attorney, perhaps even during a bathroom break, could talk about, hey, maybe we should do a plea bargain now, throw in the cards, and that would promote certain values of the administration of justice. Final point, please, page 639 of the Gaia case with Judge Posner. Judge Posner is not, I disagree with Ms. Park. There was no holding that the defense invited the Sixth Amendment violation. The holding is that the argument about Sixth Amendment violation is moot because the judge forbade the prosecutor from going into the telephone records when he cross-examined Mr. Gaia. And then Judge Posner, I could just see him giving a cocked eye to Triumph Capital on page 639. And he says, quoting Triumph, he cites Triumph Capital, he says, that is why, rather than saying that a 15-minute interruption, and this is not Triumph Capital, this is Perry, is a harmless error, the courts tend to call it a, quote, trivial violation of the right to counsel, as in Triumph Capital, which adds it's very different from harmless error inquiry. But what's meant, this is Judge Posner speaking, but what's meant, as the two cases cited just made clear, is that the fact that the appellate court is confident that the defendant would have been convicted, even if the error had not occurred, does not excuse the error, the Sixth Amendment error. It could be excused only if it was too slight to impair the defendant's right to counsel significantly. And I'm going to close by saying the error in Mr. Perry's case was not too slight to impair the defendant's right to counsel significantly. It was the opposite. It was a major error. The harm was done that first night, and intangible harm to Mr. Perry and to his counsel.
Thank you, Mr. Bickhoff.
Thank you.
Thank you again, counsel, and this case will be submitted.
I'm going to sign off. Thank you very much.
Thank you. Thank you. Second case on our docket today is 22 CV 894 CORBETT DALY et al. Versus KAISER DILLON PLLC. Counsel, when you're ready, you can come to the podium and introduce yourself and let us know how much time you would like for rebuttal.
Good morning. Good morning, Your Honors. Excuse me. Ben DeMuro and John Mook on behalf of the appellants, we'll reserve 3 minutes.
Thank
Thank
you,
you.
Mr. Demiro. Whenever you're ready to begin.
Well, thank you. Mr. Mook and I spend a great deal of our time in Virginia, but we're delighted to be here and address your honors on this case. I mentioned Virginia because we had a Chief Justice of the Supreme Court for 42 years, Justice Harry Carrico, and he was very fond about the importance of lawyers being fiduciaries. He once wrote in one of his cases that lawyers do not march to the drumbeat of the commercial marketplace. And I think that's how we should view this case today. The core standards of disclosure to a client about the mandatory arbitration clauses can be found in DC Bar Opinion 376. And for temporal importance, the DC ACAB rules and regulations that you have a link to were last amended in December of 2018. They cite and require at section 8B3 that DC Bar Opinion 376 be followed in order for a mandatory arbitration provision and between lawyer and client to be enforced. And you also see that DC Bar Opinion 376 was published in January of 2019, but obviously it had been circulated before that because it made itself into the ACAB rules. And per Opinion 376, the ACAB rules require that the client must have been adequately informed of the scope and effect of a mandatory arbitration provision consistent with LEO, Virginia, we call them LEOs, DC Bar Opinion 376. It continues, a lawyer should communicate adequate information and explanation about the material risk and reasonably available alternatives into entering into this agreement. And it gives examples of items that must be disclosed that wouldn't normally be common knowledge to non-attorneys. You must discuss the material differences between litigation and arbitration in the following respects: fees incurred, the discovery available in the two systems, the right to a jury trial being non-existent in arbitration, the right to appeal, and I don't mean appeal in the sense of motion to vacate, but appeal under normal standards of appellate law. And in this case,
Can I just slow you down on that? You think that right to appeal there means in the technical sense of right to seek judicial review of a trial court ruling on a motion to vacate or confirm?
well, I think now that you've asked the question, I think it's probably refers to both types of appeal. The waiving of your normal appellate rights under normal appellate law and your rights to appeal in the form of a motion to vacate the arbitration.
I had been assuming the latter, so so I just wanted to clarify. It seemed to me that that was a somewhat maybe imprecise term there about your ability to seek judicial review of an adverse determination, which, you know, it's not technically an appeal, but motions to confirm have a judicial review component to them. So
I think that in the discussion between the lawyer and client about the impact of mandatory arbitration provisions, you end up, the lawyer would end up conflating both concepts. While you're explaining to them in litigation, you have this type of appeal right. In arbitration, you don't have that type of appeal right. It's much more limited so that the client can make an informed consent. And in this case, you also get to the disclosure that would not be evident to a client, no matter how long they looked at the ACAB rules, that the lack of a transcript could adversely impact your ability to move to vacate the arbitration award. And that's KAISER DILLON contends that referring the dailies to the bar's website is sufficient, and that arises under their language comes from Bar Opinion 218, which is a early 1990s case, but that's superseded by 376. If you go to the DC Bar website and pull up Ethics Opinion 218, it says, quote, "This opinion has been superseded by DC Bar Legal Ethics Opinion 376.
That's certainly true, but I guess there's a question of in what way it superseded it, and your opponents argue that the way in which it superseded it was to loosen its pre-existing requirements, and that's what the substance of opinion 376 tells you, and therefore that although it's superseded, it is the way it's discussed in opinion 376 suggests that if you do what was there, you're fine, and we're loosening things, and here's our new looser standard. That's I think I mean, one of their arguments is it's not superseded, and maybe that's partly just a terminological point. It seems to you, it seems it's pretty clearly explicitly superseded by that term.
Right.
So their argument, I guess, is it's superseded in a way that suggests that some of its more strict requirements have been lifted, but that supercision doesn't undermine the tenor of both 218 and 376, that what was okay there is going to be okay under 376. I think that's the gist of their point.
I'm happy that you're not sitting at the Pelley's table and making their argument for them. I think the argument is parsing it, the history of these bar opinions way too thin. The loosening that occurred was twofold. In 376, it made it clear that any prior requirement that the client have separate independent legal counsel advising them on the benefits, pros and or risk of a mandatory arbitration provision was no longer required. So that is a loosening. And also in 376, it made clear that you can have a mandatory arbitration provision for legal malpractice claims, which had previously been questioned either in 211 or 218. I've forgotten which one addressed that. But that's the loosening, that's broadening the scope. But intertwined in several places in 376 is the language which I quoted earlier, that the client must have been adequately informed of the scope and effect of a mandatory arbitration provision, and a lawyer should communicate adequate information and explanation about the material risk and reasonably available alternatives by entering into the fee agreement. And I won't repeat the types of examples that exist in 376, but 376, while it talks about broadening the scope of mandatory arbitration provisions, also emphasizes at least twice it's in the body of the opinion and at the very end that you need to make sufficient disclosure so that the client can make informed consent. And they didn't do that in this case. The record is clear, to the extent we have a record, that and we have a record by affidavits and prior motions and motion to confirm that they did not discuss the arbitration provision with either of them, and didn't even speak with Dr.
So you think it needed to be discussed? That it wasn't enough to give them information? It actually had to be discussed.
We would follow the thoughts of both the Florida bar and the New Jersey case, Delaney, where they make it, the Delaney specifically makes it clear that it has to be a collaborative effort, either oral discussion or at least something in writing back and forth so that they can understand.
But does 376 say that?
It doesn't go that far, But
So you'd like us to put that gloss
Well,
on
I-
376?
I think it's strongly implied in the statement that you have to give the client sufficient information so that they can make an informed decision considering the material risk and benefits of the.
Right, and so what if that information were in documentary form?
Well, it's not in this engagement agreement. It
Well,
uses.
didn't the engagement agreement refer your clients to the ACAB website that does have all sorts of information on it? Am I mistaken about that?
No, it does refer them to the ACAB website, but it doesn't discuss.
Is it in the record what was on the ACAB website at the time?
I don't believe so. I don't believe so.
Okay.
And but just going to the rules and regulations of ACAB doesn't fully inform the client of the fees that may or may not be saved, the discovery that may or may not be had, the right to a jury trial, the right to an appeal, and that a lack of a transcript will deny you grounds to make a motion for vacate. And it's not just seeing black and white words, it's understanding the scope and impact of going to arbitration. And so it's the lawyer's obligation to assure him or herself that the client makes an informed decision. We are,
Your point about the lack of a transcript, I guess, is that while the ACAB rules say no transcript, we won't transcribe or record, and you can't do it either, basically is what they say.
Right.
But you think that needs to be accompanied by a discussion or arguably something in writing that would tell the client that this lack of transcript will limit your grounds for review, since you would have the inability to show that the arbitrator ignored the evidence, for example.
excuse me, I didn't mean to interrupt.
No, but I mean, your point is that
Oh,
there
absolutely.
needs to be more.
Absolutely. I saw it and I realized that the lack of a transcript would adversely impact the ability to move to vacate on certain grounds, but I've been practicing law for 43 years. I'm quite confident if you lined up 100 non-lawyers, they wouldn't understand the impact of not having a transcript on their rights. And
Can I ask you, like, if by full, one really meant every material difference between arbitration and litigation in court, there'd be a lot. I mean, it would be, you have a right, in court, you'll have a right to judicial officers who have been duly appointed and under the rules of whatever jurisdiction, whereas in arbitration, you don't. And, so there are a lot of material differences. So it seems like there's going to have to be some sort of a line back thereof, not among that list. So it's only an illustrative list. So for sure, that is not dispositive of your claim at all. And the question, though, is if we're trying to figure out how expansively to interpret the broader language, I'm just trying to get a sense of how expansively you would, where you would draw lines, including about things like the nature of the manner and selection of the adjudicator.
the list I gave you is in 376. I can't find it right now, but
No, it is. It's not an exhaustive one, but the nature of the adjudicator isn't one of them specifically on that list, is it?
no.
Right.
And there has to be some standard by which you can judge that, and 376 provides that.
And I'm asking you how you think that standard would be applied to the example I'm giving about whether you need to, informing a client adequately about a mandatory arbitration provision in an engagement letter, what you need to say, if anything, about the difference between an arbitrator, the decision maker is picked in this way. In proceedings, the decision makers would be picked in a quite different way.
your proposal, your suggestion, probably would not be discussed in this part of the discussion with the lawyer.
But
But
ask you just to step back a few layers.
Mhm.
One of the points the trial court made in denying relief was that the trial court was somewhat unsure of which specific provisions authorizing courts to set aside arbitral awards you were relying on. And I just want to make sure I understand if you have a specific answer to that question, because we don't have sort of free floating authority to set aside arbitral awards. Courts have limited authority under statutes. And so are there particular statutory provisions you're relying on as the basis for your request for relief?
yes, and there are three things that I think a record would have displayed. First is the failure to present evidence of reasonableness of fees, which is an axiomatic.
Again, my question is a little bit different from that. My question isn't what are your specific complaints about what should have been better explained? My question is there under the DC Revised Uniform Arbitration Act, there are statutory grounds on which arbitral awards can be vacated. And I'm asking which statutory provisions you were relying on.
The failure to consider material evidence or the lack of evidence in this case, number one. Number two, the chief arbitrator came up in the context of asking how long we thought it would take for this case to go forward, and he thought my estimate was far too long, and said, well, you just have to go through line items and show me which ones you disagree with. Go through thousands and thousands of time entries. That's shifting the burden to us to prove that the fees are unreasonable. And three, and this is not well developed in the pleadings, but if I had a record, I would make an effort to show how should I say, bias of the chief arbitrator. I thought he was hostile to me, but I don't have a record to prove it to you. So those are three things that we would explore if we had a record, if we had had a record.
Going back for a moment to opinion 376 and your discussion with Judge McLeese about whether the way that the adjudicator is chosen, is that something that would need to be discussed with or disclosed to the client? There is a suggestion in 376 that one relevant factor in determining what has to be discussed is whether or not a provision would give a lawyer a particular advantage over his or her client, or whether, I guess, conversely, the matter is one that could eventually adversely affect either the client or the lawyer, depending upon which way the arbitration played out. So if that's the standard, would it give the lawyer an unfair advantage over the client? What does that dictate about telling the client about the lack of availability of a transcript and the it seems that could cut either way. You could have a lawyer dissatisfied with the results of an arbitration who would want to make the point that the arbitrator had failed to consider evidence and would be equally stymied in her efforts to show that to the superior court as a client might be. So does that dictate a conclusion that that's not the kind of matter that would need to be disclosed and discussed?
No, I think that forgive the phrase that comes to my mind, what's good for the goose is good for the gander. That type of analysis doesn't fly. It's something's either wrong or it's right. And it doesn't matter if it in any given case it favors one person or one party to the contract over another. And so I think that is what we're guarding against, and I think I know the section of 376. They're talking about the imbalance of power between the lawyer and the client. And the reason you have to make disclosure is because the lawyer fully understands the scope and effect of litigation versus arbitration and a mandatory arbitration clause, but the client needs full and fair disclosure. And again, I would say that we don't have to get into all sorts of hypotheticals, but do you have to reveal this? Do you have to reveal that? Is hearsay admissible? So and so on and so forth. Can you use affidavits and that type of things? Those more remote evidentiary issues. It didn't happen in this case. They didn't get disclosure at all, except.
Well, can we go back to that? I guess I'm looking at the end of 376, right above the conclusion, where there's the list of things that as a general matter should be discussed, right? It's the fees incurred, the available discovery, the right to a jury, the right to appeal. It's saying that these are the differences that should be discussed. And then it says, as with the application of informed consent, the scope of this discussion depends on the level of sophistication of the client. And I'm wondering if that has any applicability to this case.
No, because the clients still would not understand. Well, they still need to have these matters presented to them. The words dependent on the level of sophistication of the client does not go to the items that need to be discussed. By limiting them, it goes to maybe the length of the discussion you might have to have with the client, depending on their sophistication. I can think of a spectrum of clients where you could probably cover these matters in 30 to 60 minutes, but others you'd have to take much longer, and make sure that the client goes away from that meeting and then comes back and has some time to reflect. We can't deny the reality of oftentimes what happens when clients hire lawyers. They're either they're probably being sued or need to sue, and there's some urgency to the matter, and lawyers should make an effort to fully explain these arbitration provisions and give the client their opportunity to go away, consider them, seek counsel if they so desire. And so we have to remember, lawyers are fiduciaries. We're not, this isn't as Justice Carrico said, this is not a vendor in the commercial marketplace. We rely on lawyers, and lawyers should make a full and fair effort to fully inform the client.
The other thing I wanted to ask about is the fact that 376 changed the rules in that it said that there's no longer this obligation to counsel clients or advise that clients get independent counsel regarding the arbitration provision. They said, we don't think we need that anymore. People understand arbitration clauses and they kind of have a general understanding of what they mean, right? So clients are now likely to be able to understand, I mean, whether or not you agree with this proposition is another thing, but this is what 376 says. Clients are now likely to be able to understand the complex nature of arbitration in the way that they might not have been able to in the early 90s. When arbitration was less common, and so said that this independent counsel requirement was no longer needed. And I'm wondering how that reflects on your argument. And in particular, sort of in the manner in which information is conveyed, to the extent that you're arguing there needed to be a conversation about this rather than referring a client to a website that possessed an array of documentation, including the rules, that was insufficient.
Well, just to be clear about what you're asking, it got rid of the requirement that there be an actual independent lawyer consulting with the client. That's different than advising the client that you should consider talking to an independent lawyer. I think 376 got rid of the requirement that a third party independent lawyer be involved. That doesn't negate.
Right, and I mean, that presumably was born of a concern of you're not going to get sort of straight advice from the person who's looking to contract with you. So you better get an independent opinion. And then they say, well, we don't think you need the independent opinion because we think that people are savvy enough to kind of look at these terms and decide for themselves. And I'm wondering whether that cuts against this argument of, no, you actually need to counsel this person that you might be entering into this agreement to represent. Because 376 seems to say, no, we think that sort of the baseline level of sophistication is sufficient.
What you reference is whether or not the client needs independent counsel to help evaluate the situation. That is a different concept than the lawyer seeking to have the client sign the fee letter has to make full disclosure so the client can make an assessment. Saying that the client can make an assessment in the 2000s better than they could in the 1990s still doesn't relieve the lawyer of his fiduciary obligation to be transparent and explain these are the major things you lose. And obviously we can't have a fee engagement discussion that covers every last point of the distinction between arbitration and litigation. But if you only use 376 as a standard, it wasn't met in this case.
376 talks about fee arbitration provisions being ordinary fee arrangements. There's some reference to the use of binding arbitration provisions and retainer agreements having increased significantly over the use of such language in years when the previous opinions were issued. I wonder, is there anything in the record in this case at all that tells us whether the kinds of disclosures that you think were required here are actually given as an ordinary matter or by those who were involved in this case? I mean, have you seen anywhere the kinds of disclosures that you think were required here, or did anybody point to them in an agreement anywhere?
Well, the two questions, were they actually given in this case? The answer was no. And was there evidence of what is?
I know they weren't given in this case. If that's what I asked, I didn't mean to ask it. What I meant to ask is, did anybody in the course of the record of this case make reference to any agreements elsewhere that would sort of give us some sense of whether or not it is ordinary to have agreements, to have disclosures of the sort you think were required? Does anybody do this, is what I'm asking? Is there any evidence of that?
You're asking me if I have that discussion. I do, but I know that's not evidence. You're not taking my word for it as a basis of decision making. But no, there was no discussion of what is ordinarily done. There was no expert, professional responsibility expert, things like that. But
Can I ask you another of your opponent's arguments we haven't really focused on yet is, again, this is paraphrasing a little bit, but the argument is, if you look at what's in the written arbitration provision in the engagement agreement, it in some ways it might have been overbroad, but it kind of told it was pretty clear indication that if you agree to arbitration, you're not going to have much of a shot of getting a court to overturn it. That's their argument. And what they're relying on is a language that says, by agreeing to this binding arbitration provision, you understand that you are waiving important rights, including the right to appeal. And so their argument is, maybe over broadly, what your clients was told was, you're going to be stuck with what the arbitrator does. And if I mean, that could have its own problems as being, in some ways problematically overbroad, could mislead people into thinking they don't have rights that they may have that are, but that's not the issue in our case. What's your response to the idea that why get into the weeds of here are the details of why pretty much you're going to have no way of getting to court? Because we've just told you pretty much have no way of getting to court. So why do we need to, tell you the nuts and the bolts further? That's, I think, kind of a theme of one of their lines of argument.
perhaps a flaw in our discussion is we're all lawyers. from here through the bench, we're all lawyers. We know what that means. But you have to, I would ask the court, please, to put your mind in the minds of non-lawyers. And what does that tell the client? You waive your right to appeal. Well, what does that mean? Does that mean the right to appeal under normal circumstances in a court of law? Does it tell them that your rights of appeal are better in litigation than they are under an arbitration appeal, motion to vacate? Well, that's probably true. You have a better right in the court system.
It's a very fair set of points. It has as a possible complication to it that in those terms, that was one of the things that opinion 376 said that agreements like this should include, those exact words. And should include. Now, you could say that there also needs to be discussion of them. And so that was not a ceiling, that was like a floor of you got to refer to that, and then you might need to explain more. So I get that. But I want to step back because I was kind of surprised by your answer to an earlier question that I asked, and I just wanted to follow up. When I was asking what provisions you're relying upon, you focused on your substantive challenges to the way in which the arbitrator conducted the arbitration. And I guess I had understood your argument to be something like the following, and I just want to see whether I'm getting it correctly or not. I thought essentially your argument is that because of an inadequate information provided to your clients in connection with the arbitration component of the engagement agreement, that there isn't an enforceable agreement to arbitrate here, and that you were relying on that ground for invalidating the arbitration's award, which is we can't be sent off to arbitration unless there is an adequate agreement. This is not one.
Thank you for your question. Yes, before the answer is, in my earlier response, my mind was thinking the grounds to move to vacate based on the conduct of the hearing caused by the lack of transcript. I should have included in that answer, or maybe I misunderstood the question. Certainly we attack that there is no enforceable arbitration agreement in this case.
And you think the parties seem to dispute this a little bit, but if I understand your position, you think we review that determination of the trial court, leave aside for a minute what the arbitrator thought about that topic. We review that. That's a question of law for us to determine de novo under the revised Uniform Arbitration Act. Is that's your position?
Yes, sir.
And you said something, I think you said something like the rules of professional conduct say that an arbitration agreement that relates to the fees between a lawyer and a client is unenforceable if it doesn't meet the requirements of the rule. Is that what you meant to say? And do you think that's explicit in the text of the rule, or do you draw that idea from somewhere else? I know the ACAB rules address that. That's another topic. But just the rules of professional conduct themselves, do you think they
don't specifically say that? If I said rules of professional conduct, I meant to say the ACAB rule, which is paragraph 8B3.
And that gets me confused a little bit, because the ACAB rule would be for the arbitrator to apply in the first instance. And then I start wondering about whether we really should be reviewing de novo, whether the ACAB rules requirements were or were not met, as opposed to whatever otherwise, a substantive law might say about whether an arbitration agreement independent of the ethical rules would be enforceable or not. So I do get a little puzzled about the interaction among all those pieces. Do you have thoughts on that?
Well, certainly the rules of professional conduct require fees and things related to fee arrangements to be explained reasonably. They don't say arbitration clause, but DC opinion 376 is based on lawyers' ethical duties and professional responsibility duties. And so to that extent, I would say your ethical duties and the rules of professional conduct form the basis for a lawyer's obligations.
Right. The abstract question that I'm struggling with a little bit, leaving aside the ACAB rules and who decides what and those complications, is the rules of professional conduct themselves say they're primarily directed at establishing professional norms that can be a basis for professional discipline. They're not really invariably intended to create rights in litigation, and therefore there's some possible steps in thinking from going to the idea, if you were right, that this agreement is inconsistent with the correct understanding of the ethical rules, to an arbitrator was required, either an arbitrator was required under ACAB rules to set it aside, or this court de novo reviews and would have to set aside the agreement rather than in discipline. Someone could discipline somebody for failing to follow the rules. So I just am tangled up in some of those complexities.
Certainly the rules of professional conduct do act as standards for for disciplinary actions, but they're the body of law I'm familiar with in Virginia and some in DC is that the rules of professional conduct, while they may not be the basis of a legal malpractice claim alone, can inform the standard of care. And so we would say, my argument is that they do inform the standard of care. But again, 376 sets the standard quite clearly. The law firm in this case relied on 218 and its language from 20 years ago in its engagement letter. So they recognize that they just didn't catch up with modern day requirements of the DC bar. So they relied on it back in the early days, but they didn't change it when 376, the committee woke up and said, we have to explain, we lawyers as fiduciaries have to, who have the balance of power on our side in the beginning, have to explain to the client at least these 5 core concepts. And I would add to this core concept that the lack of a transcript will cause you to lose all or most, if not all, of your rights on a motion to vacate.
Thank you, Mr. DeMuro.
Thank
We've
you.
kept you up at the podium for quite some time. We'll let you sit down.
Thank you.
We'll hear from your colleague on the other side and we'll get you back up for a few minutes in rebuttal at the end.
Good morning. May it please the court. I'm Chris Muha on behalf of KAISER DILLON. I've tried to keep track of all your questions, but if I don't address something, please just sort of let me know before I'm done here. But I'll start with that last point. KAISER DILLON's engagement agreement here complied with the text of both 218 and 376. So it did what 218 said, which is refer people to the ACAB rules. And there is a link, and it is in the record, Your Honor, to hit one of your questions. The actual link that is contained in the engagement agreement to which the people were referred.
My question was, is the information that's at the link, the information that was there, you worry about
Sure.
links leading you to information that's been
things.
updated.
Yeah. So this was only a few years ago. I haven't gone onto the Wayback Machine, but there is an internet archive that lets you check historic sites. But I don't believe the rules have been, I shouldn't say, I'm not sure whether the rules have been updated since then, but I don't think, I think they're there, and there's been no dispute, at least from the other side, when we've said they were given access to the rules. They haven't denied being given access to the rules. So we have what 218 said, which was give them a link to the rules and tell them, encourage them to go speak to ACAB staff, because ACAB staff is uniquely situated to advise you on the advantages and disadvantages of the processes and to talk to you about the reasonable alternatives. All right. Then it also had the items that matter here from 376, which was to tell them you waive the right to a jury and the right to an appeal. So we comply with the text of both, but I'd like to step back and talk a little bit then about the relationship between 218 and 376, because what it really shows is that the agreement here went above and beyond anything that is required by either of those standards. So fundamentally, they both set out the same top level standard for what constitutes to be fully informed. 218 said they have to have adequate information about the material advantages and disadvantages and the reasonable alternatives. 376 says being fully informed means having adequate information about the advantages and disadvantages and the reasonable alternatives. 218 is simply the application of that standard in a very concrete situation. And 218 made clear that it's different there because of the simplicity of ACAB's rules, the low costs of that forum, and the fact that you can be adequately advised of the risks and benefits there. It's not like going to an organization like JAMS where their business is getting you to arbitrate things. So they're going to be incentivized to talk to you about, oh, well, you should really come and arbitrate here. It's better than this. ACAB is there as a neutral body to advise you on this. It performs the same role that Mr. DeMuro will say here, you need to encourage someone to go talk to a third lawyer before signing the agreement so you can get this objective advice. We recommended that they do that. They had the ability to do that. So 218 is simply the application of that standard to a very specific kind of agreement. 376 then came along and said, because of some intervening changes in the world and in the rules, we now think it's possible for that standard that 218 set out to apply to a much broader set of cases. It doesn't only apply to ACAB fee arbitrations now, but we think it can apply to even to legal malpractice claims. What it said, where you have to draw the line, are cases, I forget which of your honors referred to this, are cases where the lawyer has knowledge that would give them an important advantage. And the example that they gave is when you're talking about taking as your fee a thing of value of the client, because the lawyer, by their training, probably is in a better situation to assess the value of that. And so therefore, that is a situation where the fiduciary obligation kicks in. But as to everything else, 376 made clear, it expressly rejected the idea that a lawyer's fiduciary relationship with the client prevents you from being able to enter into these kinds of agreements. And that is the context on which Mr. DeMuro would say there needs to be some sort of additional discussion here. I want to back up and then touch on your honor's questions, which is, okay, so let's talk about, even if there was a violation of 376 here, what does that mean in terms of what this court can do? Because there are 5 bases, I believe, in the Arbitration Act under which the court has the power to vacate an award. None of them say if you violate an ethical provision or even just an ethical opinion, that is a basis on which you can undo an award.
That's right as it relates to vacating an award, but there are earlier provisions that address the question of whether there is a valid agreement to arbitrate. Some of our cases suggest that ordinarily that's an issue for the court to determine. And that seems like that's the gist of an aspect of your opponent's argument, which is the lack of what your opponent argues is the lack of adequate information and therefore lack of an informed consent to arbitration invalidates the arbitration component of the agreement.
Sure. And so I would say 2 things in response to that, Your Honor. So the first is that they don't actually invoke that as a basis for argument in this appeal. On page 5 of their brief, and again, I think on page 30 or 33, they identify 2 statutory provisions under which they're making their argument. One is the provision that says there was a refusal to consider, quote, evidence material to the controversy. And the other is sort of the catch-all, quote, other reasonable ground for vacating an award. So I would submit that argument has been entirely waived to the extent they're even really making it.
Just to be clear, you are probably right. They don't cite the subsection, but you don't understand their argument in their brief in this court to be, this is not a valid because of the lack of information of the kind that we claim is required. This is not a valid agreement to arbitrate. You don't think they're making that argument in substance, even if they don't cite the right statutory provision? I've
taken them to be saying that because that if you don't do things the way they say, it violates 376. And that therefore, in some unexplained way, that is what gets you, this court, the ability to undo the rule. But to go to your point of like, if you were to credit that more very generous kind of reading of their brief, this would not be a de novo matter because, as Mr. DeMuro pointed out, that question is committed to the arbitration panel in the first instance by Rule 8B3. It says ACAB will enforce an attorney-client agreement to arbitrate if it is, quote, valid and enforceable. So that's the first thing they have to determine. And then it says further, the client must have been adequately informed of the scope and effect of a mandatory arbitration provision consistent with Ethics Opinion 376. And the dailies here.
To understand, you said that the ACAB rules, it depends what you mean, I guess my first instance. It's certainly true that the ACAB rules tee that up as an issue for the ACAB arbitrator. And since the ACAB arbitrator is doing his or her thing first, in that sense, it's for the arbitrator to decide in the first instance. But you're saying that because it is a topic that is one that is expressly one that the arbitrator is directed to consider, that the general provisions that seem to often treat the question of the existence of an enforceable agreement to arbitrate are kind of supplanted by the fact that in the ACAB rules, this is referred to as a matter for the it is listed as a thing for the arbitrator to decide. Is that the gist of your argument?
And not only that, but that here, in fact, they moved to dismiss on the ground that there was no valid and enforceable agreement, and the panel said motion denied. And so the effect of that then, right, like in general, matters committed to the arbitrator are given significant deference. And here there is also the general proposition, and this is from the Dalton case, which we talk about, but it's cited in a lot of places, that arbitration panels aren't overturned based on mere errors of law. In fact, there has to be, quote, manifest disregard of the law. So again, here, even if this were an error, which again, for a host of reasons, we don't think it was, I don't think you can credibly say this a manifest disregard of the law when the agreement complied with 218 expressly and also listed the relevant portions of 376 that are supposed to be in there, according to that opinion. I would submit to
And what would your answer be to the point that, well, you're right that the legal ethics opinions, and in particular 376, lists some things which at a minimum ought to be brought to the client's attention. The right to appeal, discovery rights, right to a jury, those things. But then it also includes some fuzzier language about, what needs to be disclosed depends upon the sophistication of the client. So I guess my question to you is, the fuzzy language maybe makes it not possible for something to be clearly covered by 376. What's your response to that?
A few things, yeah. So one would be, by that same token, I don't think we could have manifestly disregarded 376 if it's fuzzy in that way. Maybe we got things wrong, but manifestly so, I think that's harder to say. But I think fundamentally it's 218 in this, well, first of all, the sophistication of the dailies, there is evidence in the record that Mr. Daly was a longtime real estate broker, that they had multiple firms before coming to us. So they had some sophistication dealing with firms, including Jackson and Campbell, a much bigger firm. Dr. Kuru is a medical doctor at a hospital. So they are intelligent folks who have had interactions with the legal system. But fundamentally, I think 218 is the key here, because again, the standard that 376 and 218 put out is the same. 218 then says, in this situation, this is sort of like at the lowest level of worry about, is this a good process, or is this a process people really have to get a lot of information about? Because the rules are available, because they're simple, and because the staff is a neutral staff that can tell you about the differences between the two processes if you're interested in it. So here I would say, when you have an ACAB fee arbitration, it's almost like, icing on the cake to then list the things we went and listed. But we nevertheless did that, including, again, the most important one, which is this right to appeal. And there I would submit, to go to one of the questions Your Honor raised, that that communication to a lay person, I think, goes above and beyond what the technical, like what it means technically to have a right to appeal. And this was the exact same tack that the New Jersey Advisory Committee, to whom the Delaney Court, which they rely on, this is exactly how they recommended this issue be approached. They said that, that court basically said what they would like you to say here, which is that the basic advantages and disadvantages of the processes have to be conveyed, right? Basic, right? So not full, not full in the sense that would get them the relief they want, but just the basic advantages and disadvantages. And the advisory committee they kicked it to said, here are the things we think you should have to say. And they have a no transcript rule in New Jersey. And if you don't get your transcript, then you don't get your appeal, basically. And there they said, here's what we think you should do. You should tell people you have no right to appeal. And that, quote, if you lose or if the arbitrator makes a mistake or error, quote, there's no way to correct the mistake. The arbitrator's decision is final.
I must say, it's not the problem of this case, but it seems to me that language like that is unduly categorical has problems of over-inclusion and could be viewed as misleading folks who are sent off to arbitration, that they have no remedy, when in fact they have limited remedies, but there are remedies that exist. So that language, I get that it's over-inclusive, but it's over-inclusive in a way that seems potentially disturbing in settings other than this.
And I suppose in a case where sort of the facts were flipped, then it would be an over-inclusiveness that could have mattered. But the warnings that are counseled for attorneys to give their clients are about the risks of having less procedure. So it's about the rights you waive by going to arbitration. That's what you need to be warned about. And so this just goes above and beyond that and does it in a way that, you're right, is absolutely incorrect, but incorrect in a way that is overprotective of the lay client who is forfeiting certain important procedural protections.
Your opponent's argument, which is in part a critique of opinion 376 in a way, is that this idea that the right to appeal language kind of covered the waterfront of, by the way, no right to a transcript, and that can impede your ability to, vacate or set aside the arbitral award. It doesn't cover the waterfront. It seems like it does to us because we're lawyers or used to be, and but to a layperson, they're not thinking about motions to vacate and transcripts or any of that. So it doesn't really cover the waterfront. What's your response to that?
Right. It absolutely doesn't give the kind of detail. And I think the response is that it's almost impossible to draw a principled line at this point. If you're going to say that has to be included, what makes that a basic advantage or disadvantage? The New Jersey court didn't say that that's part of it. The advisory committee didn't say that was part of it. There's like literally zero authority they can cite to say that this particular thing has to be a basic advantage that gets conveyed. So I think that is fundamentally the part, is that you're communicating to a lay client to give them a basic idea. And again, that's what the New Jersey court recommended, that they have the basic advantages and disadvantages. And here we told them, here are people you can go talk to if you have further questions about how all this plays out.
Can I ask you, I take the point that there doesn't seem to be a lot of authority for the idea that adequate advice from a lawyer to a client in an engagement letter about arbitration needs to talk about the fact that you'll have no right to a transcript. But in part, that seems to be potentially because a flat rule saying you can't get a transcript is not a common thing. Do you have a sense of how many arbitral systems have a flat rule, which is even if you pay for it yourself, we are going to stop you from creating a transcript? It seems like it doesn't seem, as far as I could tell, it doesn't seem that common. I'm curious whether you have any better information about how common it is.
I don't. I only know of one that they've cited to the contrary. So I would submit that that's probably maybe some evidence of how prominent these are. But I think,
and it seems like I get the idea that arbitration is supposed to be a streamlined substitute for litigation rather than just, a step on the way to further litigation after the arbitration is over. So I can understand the reluctance to have a flat right to transcripts. But ultimately ACAB is a part of the DC bar, and its function in this setting is contemplated by rules this court creates. And I do wonder about the policy of a flat bar on, even if you're willing to pay for it, you just can't have a transcript. Sorry, you're out of luck.
Yeah, somewhere in the record is a model rules. Maybe it's an ABA model rule that makes it possible for a party to pay for a transcript himself or herself. And that obviously doesn't answer the question of whether that is the rule anywhere, but it's some suggestion that it might be, since jurisdictions often look to those model rules.
Or that it could be a rule here if the court were to adopt it in the right fashion. Yeah. And again, but I think what that highlights is that these are important policy questions that are appropriate in another forum when this court is sitting in a different capacity with all of its members. We're no longer talking about interpreting an ethics opinion, or to the extent that you can get them anywhere in the first place. We're talking about creating a new rule in a much different way. But also, I think substantively, to get to the policy question, there is actually some indication from the drafting history of the revised act suggesting that would be disfavored. And that is the language that we cite in our brief, where they talked about the drafting committee of the model rules on which it was based, which are not the ABA rules that they rely on. Says that, we considered having an opt-in track for arbitration where the parties could agree to heightened review of arbitration awards. But we decided not to even let parties elect that, or we're not going to recommend anyone adopt rules that even allow them to choose that, for a host of downstream reasons that would basically result in arbitration turning into mini trials and no longer being any kind of substitute. And it specifically said that if you allow that, then there's going to be transcripts inevitably. And if there are transcripts, then you're going to have to, counsel would be required to expend substantial time and energy making sure the record would support an appeal. So it's going to immediately, just the existence of a transcript, and this will be true even if one party can simply elect to do it and pays for it themselves. If a transcript is there, everyone's going to have to treat it much differently. It's inevitably going to lead to parties calling for findings of fact. They're going to say, well, yes, we have the testimony, but like, there's no credibility findings here, right? This was an argument in the Dalton case. They said, you know, we were entitled to credibility findings at our hearing, and the court denied their appeal. There are going to be calls for that. There's going to be calls for written rationales. It's going to, every other way that arbitration differs in important ways from litigation is just going to be eviscerated. And by that same logic, if you have to tell clients,
I mean, I get that line of thinking. If you're right, then either arbitration has been eviscerated all around the country because people have at least permissive transcripts, or contrary to what seems like the case, there actually are prohibitions all around the country on getting transcripts. So it seems like one of those things can't quite be right.
Agree. And fundamentally, we as a party here, I don't think we care what rules the court ends up adopting. I think what matters here is what the rules are now. And to the extent that that matters now is that the drafting history of the act suggests that as the rules are written now, as the regime exists now, the transcript idea having any kind of prominence is contrary to the drafting history of the act. But yes, if the court wants to change the rules, you know, through the process, it does so, which is not an easy thing. My understanding is, you know, that all the court has to sit plenary. Typically, the board of governors of the bar will make a recommendation first, and so there's a long process that would be short circuited here, you know, based again on almost no authority about what it means to, you know, why we should adopt the position that they're asking us to adopt here.
Counsel, I think we have kept you up here for a long time. So unless you have any other closing remarks, we'll let you sit down.
I would just emphasize, I think, to the extent that it matters, that both of the independent bodies below who looked deeply at the evidence, both did more than just award us the fees that had been unpaid, but went above and beyond that and gave us money that we had to spend to go and collect those fees. And we would ask for their decisions to be affirmed.
Thank you. Mr. DeMuro,
Thank you, Judge.
we'll give you a few more minutes.
The hated clock. We have them in Virginia too. Well, just a few points in rebuttal to Mr. Muha's points. Their argument is that the lawyer can delegate his or her fiduciary duties to ACAB. I am quite confident that if you call ACAB and start asking for advice about is arbitration better than litigation, and what do your rules mean, that they're not about to start giving legal advice. But that's my supposition. I'm not suggesting that's anywhere in the record, but that would be normal. The transcript should be available as a matter of due process, not as a matter of who's going to pay for it. We pointed out that it's the ABA model rules that recommend transcripts be available at the expense of the party, and other systems have that. I believe the Florida system has that as well. And it isn't a question of will transcripts make life more difficult for the arbitrants? Will it prolong proceedings? Well, maybe it will, maybe it won't, but there's a statutory right to either confirm or vacate, modify or alter arbitration awards, and that those rights are extinguished by the rule in the arbitration, in ACAB's arbitration rules, that there's a per se bar to having a transcript.
Can I ask you, I want to make sure I understand the relationship between your arguments. Assume that imagine that there had been the kind of full discussion of pros and cons at the time of the signing of this agreement. And one of the things that have been said is, by the way, the ACAB rules say no transcripts, and that will, you know, and there's this case, Zagaye, that will tell you that means you're going to have a hard time getting an arbitral award set aside. Are you saying that even if that has been done, that it just is fundamentally unfair and it offends due process to let people choose to voluntarily go off into an arbitration system where transcripts are forbidden?
Yes, that is our position. If the DC legislature is going to create statutory rights to vacate, modify, alter, or amend arbitration awards, and a key to that, as has been recognized in other courts, is to have a record of some sort, the transcript, then ACAB should not have a rule that says there can be no transcript. We've cited cases that say the non-existence of a transcript harmed the review on appeal, with the courts recognizing that the transcript is instrumental to post-award proceedings. And now that you've mentioned Zagay, that obviously is a very different case. In that case, the client initiated the arbitration, not the lawyers, and she, I believe it's a she did not object to the no transcript rule until after the award. She did not bring it up contemporaneously, or as in this case, prior to the hearing starting.
I mean, that's true, but I mean, the last paragraph of Zagay does not turn on it. It does not rely on any of that explicitly, at least, and instead just says, by signing the agreement to arbitrate, appellant agreed to the ACAB rules. I'm paraphrasing here. In doing so, effectively waived her right to challenge the arbitration board's decision on any grounds that would require a transcript.
Of course, we have now further guidance in the form of 376. My colleague relies a great deal on 218. 376 makes it clear it superseded 218. It doesn't endorse 218. It doesn't say, oh, we're superseding it in a limited way. All these other provisions exist. It doesn't endorse it, nor does it approve of 218. The core of 376 and the core of lawyers' fiduciary duties to clients, especially when there's that imbalance of power in negotiating a fee agreement, is that there be informed consent. They concede sufficient information was not given. They did not speak with doctor, and they did not have a collaborative discussion, either an email or by way of discussion, oral discussion with Mr. DALY. We think at this juncture, the court should order that the motion to vacate should have been granted and remand for further proceedings to the Superior Court, consistent with your ultimate opinion. Obviously, we believe a threshold question is whether or not the agreement is enforceable in the first place. At pages 2 and 3 of our reply brief, we address the waiver argument and point out that in numerous pleadings, we addressed the unenforceability of the agreement. We filed affidavits seeking to prove up the unenforceability of the agreement with the facts, and also point to a case out of this court, Biotech Pharma versus Ludwig, a 2014 case, and this court addressed whether ACAB Rule 8 and DC PAR Rule 13 gives clients the power to require arbitration of fee disputes, even though the issue had been raised for the first time on appeal. And the court says it does because it's a legal issue, even though we did not waive it below Biopharmaca.
I wonder what your response is to the point that I was discussing with your opponent. We were talking about 376 and its language that says at a minimum you ought to discuss discovery, jury rights, that kind of thing. And then you should take into account the sophistication of the client. And my question to him was, well, that last language creates a kind of fuzziness that it's difficult to say that 376 clearly makes an agreement unenforceable. There's nothing super clear about it. And his response was, well, maybe, but But the maybe may not be right, but I think I did get right the rest of his response. The rest of his response was, but in any event, you cannot say that the agreement in question here was manifestly contrary to what 376 says. That's the impact of the fuzzy language. And so given that this was a matter for the arbitrator in the first instance, if you agree that this, well, maybe you don't agree that this was not manifestly contrary to 376, what is your response to that? Because his point seems to be, so you need to leave the arbitrator's award standing because it was not manifestly contrary to 376, and thus this was not manifestly an unenforceable agreement to arbitrate.
Sophistication of the client goes to the depth in which you may or may not discuss a given issue. It does not remove from a list of topics that should be discussed from the list. The client, depending on the client's sophistication, education degrees, experience, etc., it goes to the length of time and the amount of detail that you have to go into. In this case, there was no discussion. The core of 376 is informed consent, and informed consent requires sufficient information to appreciate the material risk and benefits of arbitration over litigation or alternative remedies, I think is even mentioned in 376. So we think it's an issue of law in the first instance, but we raised it, and it isn't a matter of manifestly disregarding the law. It's a matter of whether or not you complied with your obligations as an attorney. That's all I have.
Thank you, Mr. DeMuro.
Thank you.
Thank you, counsel. The case will be submitted and this court stands adjourned.
All rise.